Today we will be discussing the justification defence, also referred to as the journalistic material defence. Our discussions will surround the UK case of Naomi Campbell against Mirror in 2004, which will also include a discussion about how the defence differs between UK and Australia. So first, let's talk about what happened in the Naomi Campbell appeal case. So there were two articles published by the defendant, Mirror newspapers. In 2001, they published one entitled, "Naomi, I'm a Drug Addict." This was accompanied by a rather unflattering image of the internationally renowned model entering a Narcotics Anonymous meeting. And these pictures were captured by an undercover freelance photographer who was following a tip-off from a fellow NA meeting attendee. So a key point here is that Naomi had publicly rejected all imputations regarding her drug problem for quite some time. And at paragraph 12, the Lords of Appeal began discussing the need to balance the familiar competition between freedom of expression and the right to an individual's privacy. So this sets out the foundations of tests developed to balance that competition and also the foundations for the journalistic material defence. So the decision in Miss Campbell's case drew away from previous approaches, if you'd like, and followed the rights set out in the European Convention of Human Rights. And it was argued that there was a breach of confidence because Mirror newspaper wrongfully published her private information. So in their decision, the Lords of Appeal gave weight to Chief Justice Gleeson's words in Australian Broadcasting Corporation and Lena Gay Meats at paragraph 42, and specifically referred to his tests regarding how to determine the ambit of an individual's private life. We won't go into those tests and we'll discuss the justification defence. The Lords of Appeal considered the fact that Miss Campbell had repeatedly and publicly denied the accusations that she had taken drugs and considered whether this precluded her from the protections of privacy. The Lords of Appeal were divided in their decision, although her appeal was ultimately upheld, and Lords Nichols of Birkenhead and Lord Hoffman were in dissent, saying that she didn't fall within the right of the privacy and that Mirror hadn't breached privacy either. So currently in the UK, there are some exceptions to the Privacy Act, their version of it, and that is basically that any sort of processing of personal data for journalistic, artistic or literary purposes where the publication and freedom of expression would be in public interest, that's okay. So this view was supported in Reynolds against Times Newspapers Limited, and in that case Lord Justice Nichols called the justification defence responsible journalism defence, and offered the view that the seriousness of the conduct being investigated and the likely strength of the source should also be considered. And a classic example of that is Julian Assange and WikiLeaks. Moving on to Australia's position. In Australia, only Victoria and the ACT have enacted bills of rights about the journalistic material defence. So the remaining jurisdictions have no formal legislative guarantees or protections. The only one that would really apply is the Australian Constitution, which protects freedom of political opinion, and that was discussed in Lang against Australian Broadcasting Corporation. The Australian Law Reform Commission have discussed Australia's position in relation to responsible journalism and public interest. Their position was that media and journalistic activities that offer a significant public benefit can sometimes justify the use of surveillance devices without the consent of individuals placed under surveillance. However, the defence should not have unrestricted freedom, and it shouldn't include things that aren't of journalistic nature and just for gossip. And that position again was upheld in Lang against Australian Broadcasting Corporation. However, in Western Australia and Northern Territory, they have a regulation called the Surveillance Devices Act, which will allow for the emergency use of surveillance devices without consent if it is in the public interest. So all up, UK and Australia are quite similar, The journalistic material defence has quite restricted application and can only be implemented when a matter of public interest applies. Thank you.